Communication from the chair.
Honorable members, those on their feet, take your seats. Kiamba, take your seat, Mami. Sabina Chege, take your seat. Honorable members, I have a communication to make on the leadership and continuity of the business of the House in the fourth session of the 13th Parliament. Honorable members, during the afternoon sitting of Tuesday, 11th February 2025, the member for Suba North, the Honorable Millie Odhiambo Mabona MP, rose on a point of order in relation to the designation of the majority and minority parties in the House and their respective leadership. In the point of order, the Honorable Millie noted that she had been aware of a judgment of the High Court in Nairobi, High Court case number E202 of 2023, Kenneth Njagi Njiru versus State Law Office and Jubilee Party of Kenya, where the court had declared the ruling contained in the communication made on 6 October 2022 on the majority and minority parties in the National Assembly as unconstitutional, null and void. In her view, the judgment declared the Azimio la Umoja One Kenya Coalition Party as the majority party. The Honorable Millie further noted that she had submitted a letter to the Speaker seeking the recognition of Azimio la Umoja One Kenya Coalition Party as the majority party and conveying the names of the Honorable Junet Mohammed as the majority leader and the Honorable Robert Mbui as the deputy majority leader. She concluded by seeking that the Speaker recuse himself from presiding over the proceedings and to allow the Honorable Deputy Speaker to recognize Azimio la Umoja One Kenya Coalition Party as the majority party, Honorable Junet Mohammed as the majority leader and the Honorable Robert Mbui as the deputy majority leader. Notably, the Honorable Millie seems to have conveniently forgotten the fact that the Honorable Deputy Speaker is also a member of a political party and represents a constituency. As such, the Honorable Millie's concerns of impartiality would still have arisen if the Deputy Speaker was in the chair. Indeed, this applies to all members of the Speaker's panel. At the beginning of the debate, I gave honorable members some general direction in the issues from the judgment as I understood them, including the fact that the judgment did not bar the Speaker from presiding over the House. Indeed, the issue of how a vacancy arises in the office of the Speaker is expressly provided for in Article 106(2) of the Constitution. Arising from the point raised by the Honorable Millie, no less than 58 other members contributed to the debate that arose, with a number raising additional points of order. This included the Deputy Speaker, the Honorable Gladys Boss, Honorable Kimani Ichung'wah, the Honorable Junet Mohammed, the Honorable Adan Keynan, the Honorable Silvanos Osoro, the Honorable Sabina Chege, the Honorable Christopher Seka, the Honorable David Ocheng, the Honorable George Murugara, the Honorable Joseph McClap, the Honorable Omboko Milemba. Other members who contributed on the point of order were the Honorable Major Retired Bashir Abdullahi, Honorable Betty Maina, Honorable John Kiari, Honorable Timothy Kipchumba, Honorable Raphael Wanjala, Honorable John Chikati, Honorable Zahir Janda, Honorable Robert Mbui, Honorable George Murugara, I think that's repeated, Honorable Doris Donya, Honorable Wanami Wamboka, Honorable Otienda Molo, Honorable Karoli Omondi, Honorable Mwengi Mutuse, Honorable Duncan Madenge, Honorable Didmas Baraza, Honorable Jane Kagiri, Honorable Emmanuel Wangwe, Honorable Peter Kaluma, Honorable Dr. Lillian Kogo, Honorable Gideon Kimaio. Additionally, Honorable Nabina Bwera, Honorable Marian Kitanyi, Honorable Sakimba Parashina, Honorable Joyce Bensuda, Honorable Captain Retired Roida Obo, Honorable Dr. Makali Mulu, Honorable Chiforo Mondo Mangale, Honorable Githinji Kishimu, Honorable Majimbo Kalasinga, Honorable Dr. Robert Pukose, Honorable Musili Mawadhe, Honorable Kasim Tandaza, Honorable Baro Mohammed, Honorable Alice Nganga, Honorable TJ Kajwang, Honorable Dr. James Sinyikal, Honorable Ruth Odinga, Honorable Geoffrey Ruku, Honorable Dr. Wilfred Oundo, Honorable Kakai Bisau, Honorable Titus Lote, Honorable Ferdinand Wanyonyi, Honorable Kuria Kimani, Honorable John Waluke, Honorable Rahim Daud, Honorable Gonsi Rai, and the Honorable Moses Kirima contributed to the debate. In broad summary, the ensuing debate crystallized the following issues. A, whether the court in its findings designated any party as the majority party or any party as the minority party in this House, and even in the affirmative, whether this was an invitation to the whips to invoke the provisions of Standing Order 19A and 20 on the submission of freshly elected party leaders. B, what were the implications of the judgment to the continuity of the business of the House, noting that the court expressly declined to grant the prayers sought by the petitioners to declare Ameamua Umoja One Kenya Coalition Party as the majority party and Kenya Kwanza as the minority party. Whether the judgment rendered the constitution of the House Business Committee, which is the core business at the first sitting of the House in a new session, impossible. Whether the judgment rendered the transaction of the business of the House impractical, and if in the affirmative, whether any intervention ought to be made so as to facilitate the National Assembly to continue discharging its constitutional responsibilities. What were the specific findings of the court in the judgment in question, and what is the effect on the proceedings and resolutions of the House in the pre-judgment 13th Parliament? Whether the judgment affects other facets of the House that are determined by the relative majorities and coalition agreements, such as the deputy party leaders, whips, chairs, chairing and membership of all House committees, membership of the Parliamentary Service Commission, nominations to the IEBC selection panel, and the Commission on Revenue Allocation. Whether the Speaker is a member of the House and how this relates to his political rights and party affiliation, and how the role of the Speaker in the House relates to the principle of impartiality. Whether certain aspects of the judgment violated the doctrine of separation of powers by constituting judicial encroachment into, 1, the internal affairs of the legislature contrary to the spirit of Article 124 of the Constitution that empowers each House to regulate its own procedure, and any attempt by the courts to prescribe a procedure for the Houses may stifle the ability of the House to discharge its constitutional mandate. The powers, privileges, and immunities accorded to the House and its membership by Article 117 of the Constitution, if matters done by Parliament officially in the furtherance of its constitutional mandate, will attract personal liability. Members at the bar, take the nearest seats. Koyo, take the nearest seat. You don't have to run across the floor. Thank you. While contributing to the debate, the Honorable Mwengi Mtusi tabled a letter dated 30th January 2024 from the Register of Political Parties indicating that the Maendeleo Chap had exited the Ameamua Umoja One Kenya Coalition Party with effect from 25th January 2024. On her part, the Deputy Speaker, the Honorable Gladys Boss, submitted that upon receipt of the judgment, while discharging the role of the Speaker in the absence of the Speaker who was out of jurisdiction, She instructed the clerk of the National Assembly to seek information from the register of political parties with respect to the status of the membership of the 21 parties represented in the House in any coalition and to request for certified copies of the relevant coalition agreements. At the conclusion of the debate, the Deputy Speaker tabled a response from the Register of Political Parties referred as Request for Information on Coalition Agreements, dated 11th February 2025. Annexed to the response were certified copies of coalition agreements relating to A, the Azimio la Umoja One Kenya Coalition Party, the Kenya Kwanza Alliance Coalition, the Kenya Kwanza Alliance Coalition and the Democratic Party, the Kenya Kwanza Alliance Coalition and the Grand Dream Development Party, the Kenya Kwanza Coalition and the National Agenda Party of Kenya, the Kenya Kwanza Alliance Coalition and Chama cha Mashinani CCM, the Taifa Democratic Coalition. Consequently, members, I undertook to consider the concerns raised by the members and documents tabled by the Honorable Mutusa and the Deputy Speaker and to guide the House at this sitting. At the very outset, I wish to note that the judgment seems to have created an element of unprecedented confusion in the affairs of the House. This has affected the manner in which I have now been called upon to guide the House in light of the patent contradictions I have noted in the letter submitted by the Honorable Millie Odhiambo. In communicating confirmation of members of the Azimio coalition as the majority, the Honorable Millie signs off as the majority party whip, National Assembly, against a letterhead that also designates her as the minority chief whip. The letter also fails to attach any records of any meeting which the alleged decision of the coalition was made as required by the very standing orders 19A and 20 that she quoted and invoked. Viewed in isolation, the letter is in law defective. Nevertheless, I'll allow the honorable member some latitude in the light of the prevailing confusion. Honorable members, I've read the judgment, and it has been explained to me at length by our very able legal team. I find it quite unfortunate that misleading assertions have been made with respect to the findings of the court. Honorable Wanjala, keep your cool. The majority of the reporting has failed to note that the matter before the court related to a mixed bag of prayers sought by petitioners touching on the pending disputes in the Jubilee Party, the Finance Bill 2023, requests for a section of Kenyans not to pay taxes, and deeming of certain members to have resigned from their political parties, among others. A reading of the judgment reveals glaring factual and legal contradictions. I instructed that an appeal be lodged against the judgment forthwith. My guidance to the House should not be construed as a review of the findings and orders of the court, and that remains within the province of the judiciary. With respect to the issues raised by the members, I can only pronounce myself on matters that are necessary to facilitate the continuity of the business of the House. Consequently, the guidance I'm about to give shall strictly confine itself within those parameters. Honorable members, I wish to note that out of 34 prayers expressly sought by the petitioners, the High Court in its findings only granted 3 prayers and expressly declined the other 31 prayers. Paragraph 508 of the judgment reads, and I quote, "In the ultimate, we allow the petition to the following extent. It is hereby declared," that's Roman 1, "that the question as to which party or coalition of parties is the majority in the National Assembly in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general elections. 2, it is hereby declared that the Honorable Speaker's ruling On determination contained in his communication from the chair made on 6 October 2022 on the majority and minority in the National Assembly violated Article 108 of the Constitution and therefore is null and void. 3, it is hereby declared, I'm quoting from the judgment. It is hereby declared that the Honorable Speaker's ruling or determination from the Chair on 6 October 2022 with respect to leadership of the National Assembly on account of his determination of the majority party and minority party in the National Assembly is contrary to and violated Article 108 of the Constitution, and to that extent is null and void. 3, an order of certiorari is hereby issued quashing the Honorable Speaker's ruling or determination contained in his communication from the Chair made on 6 October 2022 on the majority and minority in the National Assembly. Subject to the foregoing orders, the court went on. The rest of the prayers in the petition are declined. Parties will bear their own costs. Honorable members, finding number Roman 4 in which the court declined to grant the rest of the prayers sought by the petitioners is quite instructive. To put it in its proper perspective, I note that at paragraph 33, appearing on page 6 of the judgment, the petitioner had expressly sought that the court grants the following prayers, among others. D, that a declaration be issued to declare that the Azimio la Umoja One Kenya coalition is the majority party in the National Assembly of Kenya based on the outcome of the election of members of the National Assembly held on 9th August 2022. That a declaration be issued to declare that the Kenya Kwanza Alliance is the minority party in the National Assembly of Kenya based on the outcome of the elections of members of the National Assembly held on August 2022. I reiterate that it is in its final orders, and in particular, at paragraph 508, Roman 4 of the judgment, the court expressly declined to grant these orders. Therefore, in quashing the communication issued on 6 October 2022, the leadership of the National Assembly in the 13th Parliament, the court did not declare any party or coalition of parties as the majority or minority party, and neither did it declare any member of this House as the leader of the majority party, nor the leader of the minority party. This addresses the first and second issues. Honorable members, yesterday when all of you submitted, I kept quiet and listened. I implore you also to keep quiet and listen. It's a quid pro quo. Even the Honorable Millie, who raised the issue, is conducting herself like the distinguished lawyer she is, listening quietly. And for us, when we go to court as lawyers, even when the court rules against you, you stand up, bow, and say, I'm much obliged, my lord. Moving on, honorable members, in its first finding, the High Court cryptically held that the question as to which party or coalition parties in the majority in the National Assembly in the 13th Parliament was determined in August 2022. Whereas the finding of the court is a statement of fact and of law as prevailing on the 9th August 2022, the nagging question as raised by a number of members is whether the law contemplates this determination of the majority and minority parties to be static throughout the subsequent days of a term of Parliament. The Constitution itself enumerates several avenues in which the number of parliamentary seats secured by a party or a coalition at a general election can be subsequently varied. First, Article 103 of the Constitution spells out 7 instances in which a vacancy can arise in the office of a member of Parliament, including death and resignation, and this can drastically affect the numbers or members of a particular party. Secondly, Article 104 of the Constitution provides for the manner in which a member of parliament can be recalled by the electorate with the result and effect on the parliamentary seats secured by any political party. Thirdly, Article 105 of the Constitution provides for the manner in which the High Court can nullify the election of a member of parliament with the result and effect on the parliamentary seats by any political party. Fourth, Article 108 of the Constitution, as further expounded in the Political Parties Act, acknowledges the formation and existence of coalitions which, when varied through post-election agreements, have a result and effect on the parliamentary seats associated with a political party or coalition. For instance, apart from the dynamic complexities that we have witnessed around the composition of coalitions since the last general election, honorable members are also aware of the current existence of 3 vacancies in the office of members of parliament with respect to Banisa constituency, Magarin constituency, and Ugunja constituency. A further vacancy exists with respect to the nomination slot vacated by the Honorable John Badi. How is the House meant to treat a change in its relative majorities arising from the current existing 4 vacancies? Honorable members, to my mind, all the cited scenarios create avenues for the exercise of the sovereign will of the people to determine the majority and minority in the House. By quashing the guidance that I gave for purposes of ensuring the continuity of the business of the House, the court recreated the very same question that arose at the commencement of the 13th Parliament as to which party or coalition is the majority or minority in the House. Honorable